How reasonable is the policy that negates your expectation? In incorporating international law principles into our jurisprudence through PIL, the Supreme Court made use of the doctrine of legitimate expectation. We have seen that the courts, while taking the substantive approach to legitimate expectation, verify if the change in policy is reasonable. How do the courts approach an understanding of decision? The answer to this question is what we will be dealing with today. The doctrine of legitimate expectation is not a new concept in Indian laws and is considered an essential subset of Article 14 of our Constitution. In contractual sphere, as in all other state actions, the state and all its instrumentalities have to conform to Article 14 of the Constitution, of which non-arbitrariness is a significant facet. This was stated in the FCI case. In the Punjab communications case, the court decided whether the decision maker can sustain the change in policy by a resort to Wensbury principles of rationality. The court noted, "It is therefore clear that the change in policy is for the decision maker, not for the court. The result is that change in policy can defeat a substantive legitimate expectation if it can be justified on Wensbury reason. What is this Wensbury reasonableness? The Wensbury principles is based on the Associated Provincial Picture Houses Limited versus Wensbury Corporation, 1948, a UK case. In 1947, Associated Provincial Picture Houses was granted a license by the Wensbury Corporation in Staffordshire to operate a cinema on condition that no children under 15, whether accompanied by an adult or not, were admitted on Sundays. Associated Provincial Picture House sought a declaration that Wensbury's condition was unacceptable and outside the power of the corporation to impose. The court decided that it had no power to issue a writ of certiorari to quash the decision of the defendant, that is the Wensbury Corporation, simply because the court disagreed with it. For the court to adopt any remedies against decisions of public bodies such as Wensbury Corporation, it would have to find that the decision maker had given undue relevance to the facts and in reality lacked the relevance for being considered in the decision making process, had not given relevance to facts that were relevant and worthy of being considered in the decision making process, had made a decision that was completely absurd, a decision so unreasonable that no reasonable authority could have possibly made it. The court ruled that the corporation's conduct was not inappropriate and complied with the standards that had been set out. The test laid down in this case in all the three limbs, known as the Wensbury test, is used, and Wensbury unreasonableness is used to describe the third limb of being so unreasonable that no reasonable authority could have decided that way. One important fallout of the recognition of the right to equality is the element of reasonableness in qualifying or making distinctions and applying the right. Discrimination was first dealt with by applying the same treatment to two different sets of people who may not be similarly situated. Equality usually means the same treatment of those who are similarly situated. So when two sets of people with different needs, not similarly situated, are covered by the same rule, and if one of them is disadvantaged by what may seem to be a neutral rule that does not disadvantage the other, then it is not considered to be discrimination. It is seen as a weakness of the person who is disadvantaged. This approach does not recognize structural, that is systemic, or retroactive, past but with continuing effect, discrimination, and the perpetuation of stereotypes, for example, fallen woman, the good housewife, the self-sacrificing mother, etc. For example, if rules of procedure, expected behavior, processes by which a task is carried out, institutional arrangements, etc., are the same for women and men, then women may be disadvantaged in certain areas where such equal treatment fails to take into account differences between men and women, and thereby contributes to furthering inequality in terms of outcomes. For example, in Brijbala's case, Brijbala versus State of HP and others, 1984, a woman belonging to the socially disadvantaged class and ethnic group wanted to undergo training as a revenue record keeper. The Director of Land Records rejected her application. The Supreme Court directed that she be allowed to compete with men for the post through the district employment exchange. The court did not consider that she had already been denied the training and that the bias already revealed by the appointing authority, she would never be selected. As well, she suffered from historical disadvantage of being both a woman and belonging to a disadvantaged ethnic group. This is how difference is still viewed in law and in the real world. For example, women and men are different. Sometimes the difference exhibited by women is seen as weakness. Hence, it is commonly argued that they should be given different treatment even if it results in disadvantage to them. Sometimes different treatment is applied even when there is no meaningful difference. Sometimes different treatment is applied even when there is no meaningful difference. For example, women constables in Kerala were told that they could not wear pants and shirt, that is the uniform the men wore. Instead, they were asked to wear saris, the traditional dress for women. When a woman constable protested, the order was changed to accommodate women wearing pants and shirt, but the shirt should not be tucked in. When the same WPC protested, disciplinary action was taken against her, and the High Court agreed that she could disobey a discriminatory order. This is Vinaya PN versus State of Kerala, 2002. Differential treatment may be applied on the recognition of difference, which may reinforce the disadvantage already accrued. However, gradually there came an understanding that the disadvantaged deserve to exercise their rights just as others do, but because of their differences, they may need to be treated differently and be given certain benefits. Can the court, in applying the doctrine, go beyond reasonableness and fairness to need for change? In the Punjab communications case, the court considered whether the decision maker can sustain the change in policy by resort to Wensbury principles of rationality, or whether the court can go into the question whether decision maker has properly balanced legitimate expectation as against the need for a change. In the latter case, the court would obviously be able to go into the proportionality of the change in policy, that is, the change in policy against public interest. The doctrine of legitimate expectation is not a new concept in Indian laws and is considered an essential subset of Article 14 of our Constitution. In contractual sphere, as in all other state actions, the state and all its instrumentalities have to conform to Article 14 of the Constitution, of which non-arbitrariness is a significant facet. This was stated in the FCI case. In Union of India versus Lieutenant Colonel P. K. Chowdhury, 2016, the court backed and held. The doctrine of substantive legitimate expectation is one of the ways in which the guarantee of non-arbitrariness enshrined under Article 14 finds concrete expression. Reiterated in State of Jharkhand versus Brahmaputra Metallics Limited, 2020. In Bannariaman Sugar, the court backed and held it would be necessary that a ground recognized under Article 14 of the Constitution was made out by a litigant. This approach permits the court to apply proportionality and to go into the balancing of legitimate expectation and the public interest. Let us examine reasonableness under Article 14. In the Constitution of India, Article 14 protects people from discrimination based on caste, race, religion, place of birth, and sex. It is divided into two parts: equality before the law This part states that everyone should be treated equally in the eyes of the law and that no one should have any special privileges. Equal protection of the laws. This part states that the same law should be applied to everyone across society and that the state should take positive action to ensure this. Article 7 of the Universal Declaration of Human Rights, UDHR, states, all are equal before the law and are entitled without any discrimination to the equal protection of the law. Hence, the focus shifted to the need for differentiation and the justification for it. The courts first examined the basis of the classification or differentiation by the law. First, they decided that every law need not have universal application for all persons who are not by nature, attainment, or circumstances in the same position. In Amirunisa versus Mehboob, 1953, it was held by the SC that differential treatment is also discriminatory only when there is no reasonable basis for the classification. The concept of non-arbitrariness was expounded for the first time in the judgment of E.P. Royappa, 1974. It was reiterated in Sri Sitaram Sugar Company Limited versus Union of India and others, 1990. Articles 14 and 16 strike at arbitrariness in state action and ensure fairness and equality of treatment. They require that state action must be based on valid, relevant principles applicable alike to all similarly situated, and it must not be guided by any extraneous or irrelevant considerations, because that would be denial of equality. This was stated in the E.P. Royappa's case. Then they began to expand the concept, deciding in A.L. Kalra versus Project and Equipment Corporation of India Limited and D.S. Nakara versus Union of India, that arbitrariness does not always require a comparative or relative evaluation between two persons, that the term law is not confined to statutory instruments such as laws and regulations, but may also extend to government policies or contracts. And this was decided in several cases. And that even a single person may form the subject of a classification, which was decided in Ramakrishna Dalmia versus Tendulkar, 1955. That the concept of reasonableness and non-arbitrariness to be applicable and was confirmed in Dr. K.R. Lakshmanan versus State of Tamil Nadu and others, but was first decided in Ajay Hasya versus Khalid Mujib Sehrawadi. Together, the doctrine of legitimate expectation in a territory, it gives a right of judicial review in administrative law to protect the interests of people when public authority fails to do or when public authority rescinds the representation made to a person. If the objective was to be justified, a test was necessary for both the rationale and the necessity for the classification. The courts formulated the following test to assess whether the discrimination was justified. In Bhudan versus State of Bihar, Supreme Court of India, 1955, and D.S. Nakara versus Union of India, 1983, a two-step test was proposed, that the standard was adopted for a purpose rationally connected to the purpose of the statute, and that it was founded on intelligible differentia which distinguishes persons who are grouped together from those who are left out of the grouping. In British Columbia Public Services Employees Relation Commission versus BGSCU, a Supreme Court of Canada case 1999, and in K.S. Puttasamy, the Aadhaar case, they added an honest and good faith belief and also that it was reasonably necessary for the purpose. 9. The objective of the legislation or government action must be shown to be sufficiently proposing and substantial to warrant overriding another human right. R versus Oakes, Supreme Court of Canada, 1986. Unequals have to be treated unequally. St. Stephen's College versus University. This step entails a proportionality test in which the courts are required to balance the interests of the society with those of individuals in a group. In Justice K.S. Puttasamy versus Union of India, the Aadhaar case, a majority of the court adopted the following test. A measure restricting a right must have a legitimate goal. It must be suitable means of furthering this goal. There must not be any less restrictive but equally effective alternative. The measure must not have a disproportionate impact on the rights holder. Then the next step was to question the reasonableness of the procedure adopted to attain the objective. However, for the purpose of grouping logically these steps in the evolution of Article 14 jurisprudence, the timeline has not been followed. Reasonableness was extended to the means adopted to attain the objective in Lakshman Das versus State of Bombay by the Supreme Court in 1952. They extended the ambit from substantive laws to procedural laws in the case of Maneka Gandhi versus Union of India, 1978. And in that case, they held Article 14, Article 19, and Article have to be read together. Yet there are gross inequalities in relation to employment opportunities, wages, access to and enjoyment of health benefits, rights within the family, citizenship, etc. for all disadvantaged groups within India. Therefore, a new paradigm that took into account the impact of laws had to be evolved. The approach had to consider the effect of law and also its object and purpose. That is, the application is consistent with its object and whether it effected a disproportionately burdensome or disadvantageous impact. This is known as indirect discrimination. Indirect discrimination first surfaced in the decision of the US Supreme Court in Griggs versus Duke Power in 1971. In this case, a seemingly neutral policy requiring high school education for certain job posts was held to be indirectly discriminatory towards black workers who, compared to their white counterparts, received substandard education. In this case, the distinction between direct and indirect discrimination is drawn on the basis that the former needs intent, while the latter is based on effect, that is, intended and unintended. The same standard adopted by Article 1 in CEDAW. This is in contrast to the standard applicable in the UK, elaborated in Aesop and others appellants versus Home Office, UK Border Agency, respondent, Naeem appellant versus Secretary of State for Justice, respondent, where the distinction between direct and indirect discrimination is based on the fact, while the former cannot be justified under any circumstances, the latter can be justified if it is proportionate means of achieving a legitimate aim. The Supreme Court of India has adopted the intended and unintended formula based on the case of Fraser versus Canada 2020, where a two-step test was propounded to establish indirect discrimination. First, it must be shown that the measure had the effect of disproportionately impacting a disadvantaged group. Secondly, it must be ascertained whether the measure has the effect of reinforcing, perpetuating, or exacerbating the disadvantage, which must be considered in the context of historical, systemic, or structural disadvantages, if any. In the landmark case of Lieutenant Colonel Nitisha versus Union of India, the petitioner challenged the failure of the army to implement the decision in the Babita Punya case, granting permanent commissions to women officers commissioned under short service regulation. The medical fitness criteria established by the board tested the fitness of the female applicants at the current age, that is, at the time when, after the judgment, the short service commissions were changed to permanent commissions. The male officers had had their fitness tested at 10 or 14 years into their service. There had been a significant delay for the female applicants. They were made to undergo fitness exams at an age far beyond the age when male officers were tested. Also, there were other discrepancies with regard to standards for selection of male and female officers. The Supreme Court held that the promotion practices of the armed forces amounted to indirect discrimination. Justice Chandrachud laid down 5 principles to decide what is indirect discrimination. The focus of adverse effect analysis was therefore shifted to the legitimacy of the rule rather than the feasibility of the accommodation